What are the duties and liabilities of directors of a Delaware company?
Yeah, this is a good question because, of course, as a lawyer, I picked up on the the phrasing of a Delaware company, which would refer to a limited liability company, alongside that reference of a director. So typically for directors, directors are part of a corporation. You would have the shareholders elect the directors, and the directors hire the officers and appoint the officers of the corporation. This is a lot of times why people say that you want your business to be a board driven business, a business that is driven by the board of the directors. A lot of times people think, oh, it's the CEO that's driving the future of the business, or it's the COO or the CFO. Those are the people who are driving the business forward. Those are the people who are, to a certain degree, that is happening. But really, you want, if you have a board, for the business to be run and operated in accordance with the decisions and the vision set down by the board for the corporation. The board makes decisions around what they expect to see for the corporation, and those executives are ensuring that they get implemented. Where you might see connection here is that CEO role, the CEO being focused on taking advantage of opportunities for the future. They're more closely aligned with the board when it comes to their role. However, the CEO is really doing a lot of that future-based work concerning the business, as opposed to dealing with the day-to-day problems that are happening right now in the business concerning delivery and the running of it. So what duties do these directors have towards the company? Well, typically you wouldn't have directors in a company, but it is possible to adopt a corporate governance structure for a limited liability company. Remember what I said not too long ago. Limited liability companies are fundamentally creatures of contract. That means you can, by and large, make the decisions that you want to make around how the business is going to be governed, what sort of duties the different individuals have to each other. So you could, as a limited liability company, adopt a corporate method of governing for that limited liability company. You can create a board of directors where they have the same types of duties that a board of directors would have for a corporation. Instead of these being statutory based duties, these would be duties grounded in contract law versus in statutory provisions. You could also create that same relationship between the equity interest holders of the LLC and that a shareholder would have to a member of the board or the board of directors as a whole. So you can replicate that governing structure. And let's go with the assumption that that is what the person asking this question was getting at, that they have a company, but they've chosen by contract to adopt a governing structure that emulates the statutory provisions that apply to a board of directors. So what are the typical statutory provisions? What are those typical duties that a board of directors would have if you're dealing with a Delaware corporation? Now, as you know, this is not considered legal advice. This is information, and maybe a little bit of entertainment along the way. But generally speaking, you're going to be dealing with two fundamental duties: the duty of care and the duty of loyalty. A lot of times people tell me, I thought there were 5 duties. That's because the duty of care includes 3 additional duties: the duty of good faith, the duty of oversight, and disclosure. So, as a director, you have a duty to make informed decisions. You have to act with the same level of care that a reasonably prudent person would in a similar circumstance. If you're presented with information, you don't read it, you show up to meetings, you hear part of what people have to say, you understand that there's a whole a folder of documents related to what you'll be voting on, and you vote without reviewing those documents, it could easily be said that you failed to inform yourself adequately when you voted. You have to be diligent about gathering information. You have to inspect the quality of the materials that are being delivered to you and ask questions about more information if that's what's required for you to make an informed decision. It's not enough to be on the board and just rubber stamp what people are telling you must do. And courts have been clear. You can't simply rubber stamp and assume that because the other board members are making a decision that that is a prudent decision. You have an independent obligation to review and make a decision. When it comes to the duty of loyalty, you've got to act in good faith in the best interests of the corporation. And this is where I often see language in bylaws that suggests that directors don't have this duty. There's only so much you can put in writing that will actually be enforced if it were ever brought before a court. And if you're looking to sell your business later on, you have to be careful about having that type of language in your governing documents, because it suggests to the person who's buying it that maybe the directors were not looking out for the company. Maybe there are outside interests that need to be investigated. This is why you often see businesses with boards of directors also having a conflicts of interest policy when it comes to board members. So having a clear understanding of the different types of duties that a member of a board of directors for a Delaware corporation or a Delaware company that adopts a corporate governing structure, it's critical. It's critical to make sure that you're actually operating in conformity with the law, that your governing documents are ones that can be supported, and that you're operating in conformity with your governing documents. If you're looking to sell later on, it's going to make a huge difference in the type of due diligence, but also in the type of buyer that you're attracting. Think about it. If your governing structure is one where it's clear that the board members have interests that are adverse to the company, or there's a clear conflict of interest, or there's perhaps self-interest, then the type of buyers that are attracted to your business are ones who either don't think those are major issues, or they're the kind of buyers that would engage in the same behavior. It could filter into your corporate culture, and probably has, and that plays a role in who is attracted to your business. It also means that it might play a role in the valuation of your business, especially if you're relying upon the value of contracts, or a valuation that depends upon the relationships that different board members have to their customers. So if your business is built on relationships with your customers, and those board members have significant relationships with those customers, if they've helped to drive those customer relationships to the business for it to get their revenues. And you can see that there are issues with the board when it comes to the duty of loyalty, when it comes to conflicts of interest. Then the buyer who comes in is either an unsophisticated buyer who doesn't have a clear understanding of what these issues might mean for the value of the business, or they operate in a similar way, which is something to be concerning for you as a seller, depending upon how your sale has been structured over the long term. So all of this plays a role in the connection. If you have clarity over who you're looking to sell for in the future, based off of where you think the value of your business will reside, then this could be a prospect that's appealing to you, or one that's a cautionary tale that makes you rethink how you're currently running your company and how the board is playing a role in the running of your company. What are some of the liabilities that a member of a board of directors might face for a Delaware corporation or a Delaware LLC that has adopted in their governing documents a corporate structure for governing their company? Well, you have fiduciary duties, and one of the key sources for liability is the breach of a fiduciary duty. So there could be a breach of the fiduciary duty of care and loyalty to the corporation. Now, usually in a Delaware corporate entity, you cannot have these provisions in your bylaws or your certificate of incorporation that exculpates liability for breaching this type of duty. What it means is that you will often see provisions calling for indemnification and excusing essential breaches by the directors. That's usually not going to be upheld. That's usually not going to be permitted as a matter of public policy and as a matter of violating the statutes. A corporation can't include provisions in its charter, the charter being the certificate of incorporation and the bylaws and other essential governing documents and actions that protect directors when they breach their duty of loyalty. It's a fundamental duty. If they get to opt out of it by just writing a few words and signing it, then it really defeats the purpose of choosing that type of business entity structure. Okay. You can exculpate directors from some liability, but not all of the liabilities that are fundamental to their role as a director. So failing to um, failing to adequately monitor a company, failing to make decisions with sufficient information, engaging in self-dealing transactions. These are all situations that could land a director in trouble. I've seen instances, for example, where directors face potential liability because of a failure to pay employees, because the corporation failed to pay employees timely. And the directors were on notice of that, aware of it, and failed to take adequate action to remedy the situation. So it's a lot of responsibility to be a director. This is often why many individuals will not consider a director position unless there is liability insurance in place and unless they see certain indicators of a well-functioning board. They will look for boards that provide training to directors. They will look for boards with a conflicts of interest policy and other basic policies. They will look for boards that have experienced directors. They will look for boards with directors who are involved and have adequate time and attention to give to their role as a director. They will look for boards that have directors who are paid. If you're, unless it's a nonprofit, typically I see, I see many individuals who will not serve on a board without pay because it's a lot of work and a lot of time and attention, and they want to make sure that this corporation is choosing directors not based off of who is willing to sign up for free, but based off of who they truly believe is a good fit for their board composition and their needs for the business. And if that means they're willing to pay individuals to be a member of the board, then they view that as a sign of a corporation that is serious about choosing board members. So being a member of a board is a responsibility. It can land you in hot trouble, and you could end up on the hook if that corporation runs into trouble in the future.